Hello, and don't adjust your colors there on your end or your cameras on your end. This is JB Hilliard, and welcome to this week's edition of Wednesday Wisdom. Yes, it is me, and we have undergone somewhat of a transformation, but still here to provide you information on estate planning and probate and other legal concerns you may have swirling around in your head. For this week, I want to jump right in because I know I've been out for the last couple of weeks. So thank you for holding tight and tuning in for this week's Wednesday Wisdom. But I wanted to talk briefly about whether or not you are aware that there are some laws on the books of several states that suggest you may have a financial responsibility to take care of your parents, your elderly parents, if they are unable to do so for themselves. And these are called filial laws or filial responsibilities. And in a nutshell, basically what it says is that if that person, and in fact, let me read you because Georgia is one of those states that has this law on the books. And the way it reads, Georgia is very general. Some other states may be a little more specific than this, but this one for us just says the father, mother, or child of any pauper, if sufficiently able, shall support that pauper. And so basically the definition of pauper in this case is anyone who cannot maintain or provide for themselves the basic needs of food, shelter, and clothing. Now, when we talk about that shelter area or category, and particularly when we're talking about elder parents, that can get into the range of that long-term care. If they're in a nursing home or other similar facility, now you're talking about medical care. And again, specifically long-term care. And so if that parent is not able to pay that bill, that facility could essentially come after you for payment of that amount due. And of course, we're not talking about just a $25 or $30 copay. We may be talking about thousands, if not hundreds of thousands, more than likely tens of thousands, if not hundreds of thousands of dollars. So I just wanted to bring this to your attention. Elder law, Medicaid, some other issues come into play in this discussion, and this could certainly be another Wednesday Wisdom down the road. But what you want to do is make sure you're planning appropriately. I'm all about the plan. And so if you are one of those who has an elderly parent and you or your siblings may be taking care of them, you want to have that discussion to see what they have in place currently, to make sure they're not in that danger zone where they're considered to have too many assets or too much wealth to qualify for Medicaid, but they really don't have enough to foot the whole bill. So they're in that median area, that danger zone where something's going to have to happen. Some planning is going to have to happen. And so you want to have that discussion with them to see what's in place, what's needed, how that might affect you and your financial plan and your long-term planning as well as theirs, and all the other family members who may be involved. So granted, they may not be the most pleasant conversation to have, but you definitely want to have that conversation earlier versus later, because later is not going to really help you in talking about it because the deed will have been done. So get a plan together, have that discussion, figure out what's going to work, what might not work. We could talk a little bit later about the fraudulent transfer of assets, which you don't want to get involved with. So I want to put out some warnings about that. But there's a whole lot of things that we could talk about related to Medicare planning, Medicaid planning. But you want to make sure a plan is in place. So with that said, I thank you as always for watching. Who knows what you'll see next week, but please do join us again for the next Wednesday Wisdom. And in the meantime, stay safe out there, and we'll see you next time.